Very good morning to everyone. Welcome to Law and Life. This is Shashank Mishra with eminent senior advocate of Supreme Court of India, that is Subud Markandeji. Today our point of discussion is exercise of power under Article 144. On that note, my question is A.Z. Perarivalan was accused number 18 in the famous Rajiv Gandhi assassination case. He was released by Supreme Court of India citing Article 142. Kindly tell us what is the power of 142 with reference to any case that you may personally know.
We'll discuss that case on some other day, but I would like to describe today uh, the power of Article 142 of the Constitution of India. So it was one of the first cases that I got, to argue because they was work, advocate on records work. Uh, I was doing most of that in those days. But this was the first one of the first cases which I got to argue. So I was very excited. I worked very hard, and so it was Sheila Devi's case. It's an unreported case uh, because it was not a kind of uh, the court did not deliver any judgment as such, but it was a very interesting case. So let me start. Sheila Devi was an elderly lady who had a very long and acrimonious litigation with his son's wife, that is, daughter in law, in regard to the estate of her son who had died a short while ago. So the daughter in law was claiming the custody of her son, who was whose custody was in the hands of Sheila Devi, and also the property, which, and both were in possession of Sheila Devi. So there were rounds and rounds of proceedings under Section 145 of the Code of Criminal Procedure. A very interesting question arose before the Supreme Court in the backdrop of very interesting factual metrics. The records of the case showed that the accused, that is Sheila Devi, had in her lifetime forged three wills. First of her father-in-law, second her husband, and third her own son. Of course, she was caught red-handed by the daughter-in-law in forging the will of her son and putting the same in evidence in the revenue court where the suit was going on. So Sheila Devi suffered not only decree of the revenue court but also was convicted and sentenced for forgery of her son's will and putting it in evidence by the revenue court in Panipat, Haryana. In She filed a criminal revision in the Punjab and Haryana High Court, wherein the High Court, uh, passed an order in favor of Sheila Devi. Um, uh, no, I think the trial court held her guilty and sentenced her to some imprisonment, term of imprisonment. But in criminal revision which Sheila Devi filed in the Punjab and Haryana High Court, the High Court held that revenue courts had no power to punish the accused for forgery in the proceedings before that court. There was conflict of opinion between the Punjab and Haryana High Court and some other high courts. So the matter was taken up before the Supreme Court in criminal specialty petition under Article 136 of the Constitution by Sheila Devi because she challenged that. No, I think my client challenged that view. So that SLP came up for hearing, and I was very excited about that case because that was one of my first cases for arguing before the Supreme Court. The Supreme Court, on noticing that the matter essentially related to the partition of family property and the custody of young son of Sheila Devi's son, referred the case for arbitration by Justice B.N. Lokur, a retired High Court judge. Justice Lokur, after proceedings lasting for about an year, gave the award in favor of the daughter-in-law. The award was filed by the arbitrator in the Supreme Court for making it a rule of the court under the Arbitration Act of 1940. And funnily, or as luck would have it, Sheila Devi did not oppose that prayer. So the award was made the rule of the court. A decree was drawn up in terms of the award. But when the decree was put in execution by my client, that is daughter-in-law, in the executing court, Sheila Devi raised objections that the Supreme Court, while considering a criminal specialty petition, had no power to refer the case for arbitration. And for that reason, the award and the decree were nullity and not executable. So the matter came up for hearing before a bench presided over by Justice P.N. Bhagwati, and she and and the bench, called upon me to justify the reference of the case to arbitration. After all, it was their order, but I had to justify. But the only thing I could touch on was Article 142, and it turned out to be a very powerful one. The judges called the lady closer to the bench. She was attending the hearings and asked her whether she knew English. So she boasted, yes, she had taken degrees of BA and MA from University of Punjab. So then the judges very politely said that, Madam, maybe we have or probably do not have the power to make a reference to arbitration in a criminal specialty petition. But even you will not uh, doubt that we do have power to set aside the judgment of the High Court and maintain the conviction and sentence of the sentence given by the trial court. So the choice is hers. The case would come up after 2 weeks. In the meanwhile, she should make up her mind to either go to jail and serve out the sentence, or alternatively voluntarily execute the decree in letter and spirit. The trial court was directed to certify that decree has been executed in letter and spirit. So, needless to say that Sheila Devi executed the decree to the hilt, and trial court also certified that she had executed the decree and handed over all the properties to the daughter-in-law. So this is not a filmy story; it's a true one. So I realized for the first time that uh, Article 142 was a very, very powerful provision of the Constitution. So that's it.
Thank you, sir. Thank you for the experience about the Sila Devi case. And thank you for joining, sir. Hope to we can see such videos again, sir. Thank you, sir.